Dave Chappelle is once again under fire for what some say are homophobic and transphobic remarks. In his stand-up set released on October 5th, Chappelle doubles down on his jokes about the LGBTQ groups and doesn't spare blacks, Asian, Jews, and whites on his set. The commentary raised by the LGBTQ community is that his remarks are homophobic. Let's discuss this, but first, if you're curious, my name is Miriam Greenidge and I'm an attorney, and this is The Legal Code, the channel dedicated to discussing various legal topics circulating or which should be circulating. On this channel, we discuss various legal things going on in pop culture, current events, but important legal topics confronting our culture and society from which we can all learn. If you like that sort of thing, don't forget to like and subscribe and share this video if you think it would be helpful to anyone that you know. So let's get into this video. So the day after Dave Chappelle's show was released on Netflix, a software engineer by the name of Terrafield tweeted that the comedian, quote, attacked the trans community and the very validity of transness, end quote, in his special. The tweet thread went viral, quickly spinning into a conversation about free speech and cancel culture, of course. Netflix then suspended Field along with two other employees for trying to attend an executive level or director level meeting to which they weren't permitted or invited to attend. Another trans employee quit the company over how the special and Field's comments were handled. Netflix spokesperson denied the idea that Field was suspended for tweeting. Quote, "It is absolutely untrue to say that we have suspended any employee for tweeting about the show." He went further to say, "Our employees are encouraged to disagree openly and we support their right to do so." So as we can see, Netflix is adamant about its employees expressing dissenting opinions about Netflix, even if it's not the popular opinion at Netflix. On October 8th, Netflix co-CEO Ted Sarandos responded to the question in an internal email. And he quoted in saying, "It never feels good when people are hurting, especially our colleagues." He also wrote, "You should all be aware that some talent may join third parties in asking to remove the show in the coming days, which we are not going to do." So as you can see, Netflix doubled down on its support of Chappelle's set. Sarandos also said that Chappelle's last special, Sticks and Stones, is Netflix's most watched, stickiest, and most award-winning stand-up special to date. So it sounds like Netflix has shown adamant support for Chappelle. He also added, "Several of you have asked where to draw the line on hate. We don't allow titles on Netflix that are designed to incite hate or violence, and we don't believe the closer crosses that line. I recognize, however, that distinguishing between commentary and harm is difficult or hard, especially with stand-up comedy, which exists to push the social boundaries. Some people find the art of stand-up to be mean-spirited, but our members enjoy it and is an important part of our content." So as you can see, Netflix is okay with being controversial and supporting artists that are controversial and provocative and make us think. Sarandos exemplified the network's commitment to inclusion, which is reflected in titles such as Sex Education and Disclosure, which are documentary about Hollywood's impact on the trans community. So you see Netflix balancing provocative rhetoric with supporting inclusion. Nevertheless, despite this commentary, some employees are not convinced that Netflix is being sensitive by airing the comedian's set. The Closer has drawn criticism from GLAAD, which tweeted that, quote, "Dave Chappelle's brand has become synonymous with ridiculing trans people and other marginalized communities," end quote. In a statement to Variety, the National Black Justice Coalition said, quote, "Perpetuating transphobia perpetuates violence. Netflix should immediately pull the Closer from its platform and directly apologize to the transgender community. So very contentious subject, as we can see, and Netflix is getting it from all sides. Despite these sentiments, does Chappelle's set qualify as hate speech though? And if so, what should we do about it? Or should anything be done about it? And that's what we're going to discuss in this video. Before I get into this analysis, I want to preface that hate speech and First Amendment rights can be complicated and dense to understand for lawyers and non-lawyers alike. But I feel no reason to simplify how courts analyze it, and especially the Supreme Court. How the Supreme Court handles it, I believe that my audience, all of you, are perfectly capable of understanding. More than ever, people are extremely knowledgeable and self-taught in so many areas. So I trust that you will be perfectly able to understand how the jurisprudence or the laws are handled in this area. So let's look at the Supreme Court's definition of hate speech, which is the prevailing source for defining speech and what is protected and what is not protected. Speech is generally protected under the First Amendment unless it falls within one of the narrow categories of unprotected speech, which I will get into in this video in a little bit. In academic circles, there has been a debate over freedom of speech, hate speech, and hate speech legislation. It's a very contentious topic. The protection of civil liberties includes freedom of speech, was not written into the original 1788 Constitution of the United States, but was added 2 years later with the Bill of Rights, implementing several amendments to the Constitution. The First Amendment provides, in relevant parts, Congress shall make no laws abridging the freedom of speech or of the press. The 14th Amendment, ratified on July 9th, 1868, has been interpreted by the Supreme Court as extending this protection or the prohibition to laws enacted by the state. So this federal protection that prevents the abridging of freedom of speech or the First Amendment, as well as state law. There are certain categories of speech which the Supreme Court determined to not have free speech protection, nevertheless. On the other side of the table, there is content-based laws or laws that apply to a particular speech because of the topic discussed or the idea or message. So it's content-based speech. There's an intended message behind the speech. Yet the law does not want to limit ideas. So this type of speech is generally protected. And laws that aim to limit speech are presumably unconstitutional and subjected to the strictest scrutiny. Strict scrutiny is the analysis used by the court when dealing with certain topics. So essentially unconstitutional to pass laws that limit a particular speech because of a topic. These categories of speech that can be regulated are as follows. We have obscenity, defamation, fraud, incitement, fighting words, true threats, speech integral to criminal conduct, and child pornography. So we're going to discuss briefly, though, each of these categories just so you can know the types of speech which are prohibited and allowed to be regulated both on the state level as well as the federal level. The first category is obscenity. In order for material to be seen as obscene and thus unprotected under the First Amendment, it must appeal to the prurient interest in sex in a patently offensive way and lack serious literary, artistic, political, or scientific value. So this is the Supreme Court's definition of obscene. So essentially something or speech that is gratuitously vulgar speech about sex. Next category, defamation. Defamatory statements are false statements of fact about a person and are not protected. Also, fraud, another category, recognizing that some false statements are inevitable. False statements can form the basis of other legally cognizable harm, such as defamation or fraud. So false speech is not protected. The government may regulate fraudulent speech in order to prevent public or consumer deception. So there's an impetus to regulate this type of speech in order to protect the public. Next, incitement. The Supreme Court held that the First Amendment protects advocating the use of force or law breaking only if it does not advocate to directly incite or produce imminent lawless action. So you could pretty much say violent things as long as it does not come close to harming somebody or produce an action that's violent. Likewise, fighting words. So in 1942, the Supreme Court held that the First Amendment does not protect fighting words, those likely to provoke the average person to retaliate and thereby cause a breach of peace. So we see the court saying if the speech can rise to the level of causing violence, we are not protecting it. Similarly, true threats to communicate a serious expression of intent to commit an unlawful act are also not protected. Speech integral to criminal conduct is not protected. The court does not want to endorse protecting speech that leads to illegal conduct. So this is rather obvious. And lastly, we have child pornography, which of course the court is not going to protect the advertising and sale of material that underlies criminal conduct and harm to children. So those are the categories. And as we can see, hate speech is not one of the categories defined by the Supreme Court. The Supreme Court has been reluctant to include hate speech as an additional category. While the Constitution guarantees free speech and free press, it does not permit a state to forbid or prescribe advocacy directed to inciting imminent, so it must be immediate, lawless action, and is likely to incite or produce such action. So the Supreme Court is not endorsing speech that will quickly lead to a rise to violent action. So the government does not want to limit speech unless it directly leads to physical harm to a person or a group of people. Hate speech in the United States, interestingly enough, cannot be directly regulated due to the fundamental right to freedom of speech protected in the Constitution. Secondly, while hate speech is not a legal term, the United States and the U.S. Supreme Court has repeatedly ruled most of what would qualify as hate speech in other Western countries is legally permissible and protected as free speech under the First Amendment. So as you can see, the Supreme Court in the United States has the broadest definition of speech and wants to encapsulate as much speech in that definition and limiting speech for certain categories. Generally, however, hate speech is any form of expression through which speakers intend to vilify, humiliate, or incite hatred against a group or class of people on the basis of race, religion, skin color, sexuality, gender identity, ethnicity, disability, or national origin. So hate speech has to deal with speech directed at a particular class that is vulnerable. Despite this effect, the Supreme Court continues to protect this type of speech. Now let's look at how courts have handled hate speech rhetoric, or conduct that equates to hate speech. In 1992, in RAV versus City of St. Paul, the issue of targeting hate speech arose again when a group of white teenagers burned a cross on the front yard of an African American family. The local law in St. Paul, Minnesota, criminalized symbolic expressions tantamount to fighting words, arousing anger or danger on the basis of race or other protected classes. So St. Paul had this law that said any conduct that arises to incite violence based on a protected class is illegal. So the deceased Justice Antonin Scalia wrote in his decision for the Supreme Court, explained that the ordinance or the law was unconstitutional. The law that criminalized burning crosses was unconstitutional because it contravened the First Amendment by focusing on a particular groups to whom speech was restricted, or essentially the ordinance curtailed a particular group's free speech. So in essence, ordinance curtailed racist rhetoric. Scalia went on to explain that the reason why fighting words are categorically excluded from protection is that it leads to not only having a particular idea, but that content leads to violence. but that content embodies a particular intolerable mode of expression that leads to violence, and we want to regulate that and limit that. However, burning a cross does not rise to that level of violence. So, essentially, because the hate speech law was not concerned with the mode of expression that violence would result, but that the content of expression that these people hate this group of people, it was a violation of freedom of speech. Thus, the Supreme Court embraced the idea that speech in general is permissible, albeit offensive, unless it leads to imminent violence. So unless there was speech or conduct that led to violence, it's not enough to curtail this type of rhetoric. We want to embrace this type of rhetoric, even though it's offensive and offends the sensibilities of many. A few years earlier, in 2003, the court, in a 7-2 majority opinion written by Justice O'Connor, the court decided that a law which criminalized public cross burning was unconstitutional, similar to the case holding in St. Paul case. The court noted that the law would be constitutional if the law included an element of specific intent to inspire fear of bodily harm, instead of concluding that cross burning is evidence of intent to intimidate. Therefore, the court pretty much meant that if the law sought to limit specific threat of harm, then it would pass muster. However, cross burning does not rise to imminent threat. Not enough for it to be limited, even though it's terribly offensive to many. And most recently, in 2017, the Supreme Court once again said that it will not codify hate speech or treat it as another category to be curtailed or limited. The idea that the government may restrict speech or expression of ideas that offend strikes at the very heart of the First Amendment. Speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful, offensive, and deplorable. But permitting it reflects and exemplifies the proudest boast of free speech jurisprudence. We want to protect freedom of expression, even in its offensive boundaries. So essentially, even if the speech is distasteful and socially deplorable, we still want it. The court does not want to limit speech because of its contents carrying a message that could be seen as offensive. A law that can be directed against speech found to be offensive to some portion of the public is detrimental to all. The reason for this is because the Supreme Court is the sword of the Constitution and want to safeguard free and open discussion in a democratic society. So the court is pretty much saying we have to get comfortable with hate speech, even though it's offensive, it's not nice, it's demeaning, it's marginalizing. We want it because that's an earmark of a democratic society. So in these cases, we see examples of hate speech. We see abusive language, specifically attacking a person or persons because of their race, color, religion, ethnic group, gender, sexual orientation. Yet it's protected. We see the court saying burning of cross is an idea of expressing hate toward a group of people. Even though it's offensive, we don't want to limit it because that contravenes democracy. This position is that speech must be valued as one of the most important elements of a democratic society. So we don't want to move toward limiting speech. We want more speech. Once we start limiting, how far will the limits go? How boundless would it be to define what should be said and what should not be said? So now we see how the law deals with it. Now let's circle back to Dave Chappelle. Does his rhetoric fall within the category of hate speech? Is it necessary or purposeful that it be limited? Or do we want to support ideas of expression and art, albeit offensive to some? And do we want to cancel him because of this? I don't think so. As a matter of fact, I vehemently am against it. So now we see how the law deals with hate speech. Does Chappelle's rhetoric fall within that category? I don't think so. Does Chappelle's content aim at causing harm towards a group, or is it merely social commentary which is provocative, which essentially is the platform of most comedic acts. Will his speech result in harm or further harm to the transgender community? I think we're a far cry from that. But let me know your thoughts. Don't forget to like and subscribe and comment. Let me know your thoughts. Have you seen the special? Do you think it's offensive? Do you think Dave Chappelle is equal opportunity offensive? What do you think about having provocative commentary in comedic sets? Let me know. Thanks again for watching. Bye-bye.